top legal luminaries with us. I would like to introduce our first guest. He is Justice V. Chidambaresh. Justice Chidambaresh is the former judge of Kerala High Court. He retired in November 2019. His specialization is in criminal, civil, constitutional, services, cooperative societies, and educational related matters. To his credit, number of reported cases as advocate are 300 and as judge are 500. During his tenure, he disposed 25,856 cases. Welcome, Honorable Justice V. Chidambaresh, to our show.
Thank you, sir.
Honorable Chidambaresh, Justice Chidambaresh, you have heard and you have seen that today the condition in India after this lockdown started, all the courts are basically working virtually, including Supreme Court and High Courts. The disposal rate has gone down because only the urgent matters are being heard. Now, we would like to know from you about COVID-19 impact on criminal cases in India. Justice V. Chidambaresh, please.
It is often said that justice delayed is justice denied. Now, justice is delayed because of this pandemic. There is a practical stagnation in courts. There is no serious transaction which take place in court, other than considering applications for bail and anticipatory bail. No trial takes place. Now, virtual hearing is not a substitute for actual hearing or physical hearing. Now the under trials are granted interim bail. They are not keen on having a quick disposal of the cases because they are on interim bail, they are enjoying bail. Many cases are pending in appeal revision. All these accused persons are only interested in protracting the litigation, and this pandemic helps them, in fact. As far as the courts are concerned, for example, the Supreme Court, it is centrally air conditioned. There cannot be a physical court sitting now because footfalls are about 5,000 per day, and one positive case will lead to spreading of the disease to all other persons. But virtual hearing also is not completely satisfactory, in the sense a case is being called on for hearing. The three judges, they talk between themselves, arrive at a conclusion, and then says that verdict to you: we are admitting the SLP, we are dismissing the SLP, we are granting stay, we are not granting stay. So that very little scope is there for the lawyer to argue and convince. Of course, I should concede that judges are a bit liberal for virtual court hearing than in physical court hearing. But a proper substitute should be found out sooner than later. The pandemic may take months to vanish, and the courts cannot remain still till such time. A suitable alternative should be found out. Of course, live streaming is always welcome. Even when physical courts work, live streaming can take place. As far as the subordinate courts are concerned, the trial should be confined to 2 or 3 days. One particular case should be taken up. It should not be adjourned. It should be confined to 2 or 3 days. Trial should be over within the time, so that other litigants and other lawyers can be kept out. That is one option for the criminal courts to surge ahead. Otherwise, the very purpose of this justice delivery system becomes futile. Now I call upon Mr. Deepak Dhingra to...
Thank you, Justice Chidambaresh, for giving your views. And you said that virtual courts is not the only solution because this disposal is less, as well as it's not possible to give the decision or the judgment properly, because earlier the judges used to talk to each other and decide about the dismissing or admitting the SLPs. But now once it is a virtual, it's not that possible. And he has also mentioned that it is also not possible to start at this juncture the physical courts, because the footfall is so high that if one person is found positive, it will be very, very difficult to run the court. Now I would like to go to the we have a senior advocate here. He is a senior advocate Vivek Sood. He is the senior advocate of High Court, Delhi High Court. He is having more than 3 decades of experience at the bar. His areas of specialization are business laws, economic offences, constitution law, technology laws, etc. He authored several books on the law of information technology and constitutional law. He speaks regularly on legal issues in the media. Welcome, Senior Advocate Mr. Vivek Sood ji. Now, you have heard what Justice Chidambaresh has mentioned, and he has mentioned about that virtual courts are not the solution. He has also said that at this moment, because this pandemic will take more time now, is not possible to have the physical courts. Now, we would like to know COVID-19 impact on criminal cases in India. At Senior Advocate Vivek Sood, please.
May I start by saying that there is a virtual lockdown of Article 21. So, since there is no trial, there is no question of a fair trial. Article 21 speaks of, fair trial. Fair trial is one of the important features or facets of Article 21. So, without a trial going on, there is no question of a fair trial. If I may say so, the legal system, if the legal system is affected by the COVID-19, the gravest impact is on criminal matters, because liberty of the individual is at stake. People are languishing in jail under trials, or convicts whose appeals are pending in the High Court and the appellate courts. They continue to languish in jails without appeals being heard, without revisions being heard, without trials progressing at all. Now, in this scenario, the Supreme Court passed certain orders in the month of March, saying that every High Court should appoint high-powered committees consisting of, the executive and the judiciary, and they should make some policy with respect to release of prisoners during the COVID-19. Now, as per those policies, I have gone through some of the policies, for example, the one made by Delhi High Court and the other states. I've gone through those policies, and I find that a brave effort has been made to release certain types of prisoners on interim bail or on parole, etc. However, that needs to be expanded. Now, I will be, since I practiced on the criminal side for over 3 decades now, I can, I can maybe give some inputs as to the way forward. Now, I find that many of these policies of the high-powered committees are quite limited in terms of giving relief to the prisoners. For example, some of the policies say that prisoners who are accused or convicted of offences where the punishment is more than 7 years will not be eligible for being released. All those accused who are accused of sexual offences or convicted of sexual offences will not be released. In all those cases where the ED is the law enforcement agency, CBI is the law enforcement agencies, those accused also will not be released. Where accused are involved in multiple cases, they will not be eligible for being released. Now, I find many of these policies, many of these strategies to be quite limited. Now, since the pandemic is not going away in the near future, the pandemic is here for the next 6 months at least. Now, I can just throw light on this. For example, the population of US is about 30 crores. Our population is about 140 crores, about 4.5 to 5 times. And US has about 25 lakh cases, 2.5 million cases. We are still at 5.5 lakh cases, and it is yet to peak in the US. So in my view, the peak in India is far, far away. So, you know, we can't keep those convicts and accused languishing in jails. At the same time, the trial is not progressing at all. So we need to devise a more expensive strategy, which is a win-win. See, I'm not trying to say that all the criminals, all the convicts should be out in the streets. You know, no, that's not what I'm trying to propagate. Now, the strategy which I have in mind with experience is something like this. Interim bail is well known to law. Parole is well known to law. Furlough is well known to law. Now, these are interim reliefs which have been granted by the courts since time immemorial to all kinds of accused. There is no restriction. I have seen so many accused who are accused of murder cases, convicts who have been convicted of heinous offenses, being released on interim bail, being released on parole, being released on furlough. In fact, furlough is a relief in Delhi, for example. A person comes out for about 7 weeks in a year, 7 or 11 weeks in a year, and the criteria is where the punishment is more than 5 years. It is actually, the whole concept is that jail leads to depression, leads to disconnect with the society, disconnect with family ties. So all those convicts who are incarcerated for long jail terms like lifers should be released for about 11 weeks every year, and that period is counted towards the sentence. Frequently, courts grant interim bail to all kinds of accused without any restriction as to the quantum of punishment, multiple cases, blah, 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 without any restriction. Now, the strategy I can propagate is wherever an accused or a convict in the past has been released on parole or furlough or interim bail, of any interim relief has been granted to him in the past, and if he did not misuse his liberty, irrespective of the nature of the offense, he should be released on parole, or you may call it interim bail, or you may call it furlough, as the case may be. So in my view, since the pandemic is not going away, we need a more expensive strategy, you know, so that convicts and accused who have good antecedents. For example, a person was released on interim bail for 4 weeks or 6 weeks. He did not misuse his liberty. He surrendered back in jail. Why should he not be released on interim bail or parole or furlough at this point of time? Why should there be a restriction that since you are involved in a case where the punishment is over 7 years, we will not release you? So I find that we need a more expensive strategy, so that there is a balance between, we don't want criminals on the street. At the same time, it will be grossly unfair for keeping convicts and accused in jail, languishing in jail, without their trials moving at all. So therefore, I feel that we can expand the strategy to get more people out on interim bail during this pandemic. The last point I wish to make is, pandemic is not going away. Therefore, and the virtual hearings have not been a success. Let's face it, the judiciary is not able to dispose of or take up maybe 0.0001% of the total workload. Out of 3 crore cases, if you are able to do only 1,000 cases, it means nothing really. So in my view, the judiciary will have to come out of its shell in some way. If malls can open, if the markets can open, if the airports can open, if the corporate world can open. I know people, I know friends, I have people relatives who are going to their offices. They are calling their employees. They are maintaining the social distancing norms, etc. The government is working. When all these things are gradually opening up, in my view, the judiciary will have to come out with some plan to open itself for physical hearings, or at least a choice may be given to the lawyers. Some lawyers may want to be at home, give them a virtual hearing. Some lawyers who want to come to the courts after taking adequate safeguards. See, I realize that courts, especially lower courts, are like fish markets. They are like crowded marketplaces. But so therefore we need to find some way out, with social distancing, etc., etc. See, just by keeping yourself closed and doing an infinitesimal fraction of the workload of 3 crore plus cases, you do 1,000 cases or 2,000 cases will not serve the purpose. We already are overburdened with cases. We will go behind by at least 5 to 10 years if this continues for another 6 to 8 months to 1 year. So a strategy will have to be worked out where some kind of physical hearings do begin. See, we all know most of the cases are asymptomatic cases. Out of the cases that have symptoms, most people, get cured sitting at home. So even if you have some pandemic cases, some cases of COVID-19 in the courts, fine. That person goes into a self-quarantine or to a hospital, gets himself cured, comes back on the seat. So it is not something, I think the media has also overplayed this COVID-19. It's, the mortality rate is extremely low, 0.1% or something. So I feel that some balance has to be struck, between safety and Article 21. Thank you.
Thank you, Senior Advocate Sood. Some balance has to be struck between the safety and the Article 21. And as you have mentioned that there is no fair trial is taking place in the virtual courts. You have also mentioned that the 3 things which one can be consider leniently, they are the interim bail, paroles, and furloughs. And you have also given suggestions according to you when malls and all restaurants and the airports can open, why not the courts can start working with keeping the social distancing. Now I would like to go to the next panelist. Next guest is Advocate Sunil Bhargava. Advocate Sunil Bhargava is mainly practices in criminal cases of murders, etc. at Mathura, Faridabad, Palwal and Bharatpur. He was the Secretary and President of the Bar Association of Mathura. He was the Zone and Region Chairperson of Lions Club International of District 321C. He is a Melvin Jones Fellow of Lions International. He captained Lucknow University and were runners-up in All India Inter-University Tennis Tournament at Tirupati in lawn tennis. He represented UP in veteran cricket team and became Secretary of UP Veterans Association. He also represented UP in All India Masters Badminton. Welcome, Advocate Bhargava, on this show. Now, you have heard what Justice Chidambaresh has said and what Senior Advocate Sood has said, that virtual courts are not the solution. And they said that because the case pendency is so high and we are getting so many cases, it's not possible to give the relief to the accused by the virtual courts. Now, you are practicing at lower courts, at Mathura and other places. And there the courts are functioning physically, where you are attending the court. So now we would like to know from you, COVID-19 impact on criminal cases in India. Advocate Sunil Bhargava, please.
First of all, let me thank you for inviting me to this place. Because Honorable High Court and Apex Court lawyers have a better say, our side, we really have to work hard to make our voice go further. We are working in this, Justice just said, justice, if it is delayed, it is denied. In Sessions Court, I've been working in 3 states, and I realized the bigger the state is, the more problem it is. Pendencies before this pandemic also was very high in our states. In a sessions trial, we have to, it is like wait for 15 years for a judgment. And maybe in an appeal, it can be even 2 or 3 decades. And people are there, they are enjoying bails. People are waiting that justice should be done, but it could not be done. Now, after this pandemic, things have really changed. Everybody wants justice on the faster side, but we have to think both ways. It is not only for the accused we have to think. It is for the complainant also. It is the other party who's aggrieved. His thought should also come forward. Like what is happening in our side now is people who are accused in less than 7 years, that's what my colleague said earlier, they are already released on parole. And people who are on the higher side, like murders, attempt to murders, rapes, etc., their bail applications are being heard. So they are getting justice. But what this pandemic has done is, we are already waiting for such a long time for these cases to conclude. People are waiting for justice from both sides. Now, if this case does not start, if whatever a person who's suffering right now, what happens in this lockout, the person who's in possession in a civil case, he changes the whole case. He changes the issues. He gets construction done at his place, which he is in possession, nobody can help him out. What will happen to such cases? So what my thinking was, cases have to be concluded in a faster manner. Otherwise, the things people are waiting for justice, they will keep waiting for ages to come. Now, in our side, we are getting bail applications heard. But trials, Honorable High Court tried the trial should be there with distance maintaining, a curtain in between the judges and the lawyers in the courtroom, creating distances, and they started evidence also. But unfortunately, in a criminal trial, evidence of a witness is to be recorded, evidence of investigating officer and other evidence is there. That is what we call evidences of check writers, etc., etc. Then the accused has to be examined under Section 313, and then only a trial can conclude. But in these circumstances, what is happening is no accused is coming out of jail. They are all in jail. Witnesses are not coming. Police personnel and other personnel don't have the time to come to the court. So this is basically leading the delay which is already there. More delay is coming. It is people from the side of complainant. Suppose somebody is complaining in a murder trial. He has lost one or few of his family members. How long will he wait? Don't you think that revengeful attitude will come in? People will take revenge, like a matter of abatement by the High Court when it comes to appeal here. It is such a delay that maybe the thinking is within 25, 30 years, by the time this appeal of a murder is being heard, complainant will not wait. He will lose patience in such a long time. And he might react, getting more cases of criminal sides coming in, because he will also take weapon in his hands. But to avoid all this, we have to hurry up also. It is basically need of our state, because maybe we have more criminal cases, more murder trials, more everything of criminal side. So we have to, satisfy both sides. Otherwise, it will be very high cases. A lot of cases, new cases will be coming up like they are coming up right now. Because of this pandemic, maybe cases are less, but the other criminal offenses are coming in. People are coming in with theft, robberies, etc., etc. And because they are less than 7 years, they are going out. So once they go out on parole, they will not wait, they will do it again. Now, what will happen to people who are sufferers? So I think the way things are going, and the pandemic, of course, we all know, like all my senior colleagues have already stated, it will take time. We have to live with it. We have to work in it. We have to do our natural ways, whatever we are living. Every day we have to. So once that is there, my suggestion to the whole thing was, we can start, but like we were starting through conversations, through a computer only, but that can be a solution. If we can improve that, let witness come on a computer, let cross-examination be done there only, let it be recorded, and then also we can go into final judgments, which will probably enhance the whole systems. So what we are waiting for, I do believe in the same thing. Justice delayed is justice denied. So we should not wait. We have to work. It is very correct that a lot of lawyers, like us also, we are afraid wherever the crowd is, wherever people are not taking precautions, we are really worried to go and work in these courts. But if those precautions are taken forcefully, if we are given that protection, maybe the senior lawyers are not appearing also in cases because of that. They can appear. And then we can prolong, instead of prolonging the issues, we can get criminal cases at the fastest. And that is my suggestion. That can only come not through direct evidence as we were doing it, because we have to get evidence into criminal cases. Let it be through media only, and let it what the High Court initially started off. That can be at the earliest, so we can throw away the problems which are coming into the society. We can fight the whole system, and we can start our work early. That's my suggestion.
Thank you, Advocate Bhargava. We can start the work earliest, and according to you, the government should consider to start taking the evidence even on virtually and cross-examination also, so that the speedy justice can be given. Because according to you, it is not the only the accused, but the question of complainant also is involved. After all, the complainant who has made a criminal complaint, he is also having his own right that he should see to it that the crime, who has done the crime should be behind the bar, not outside. Now I would like to go to our next guest. He is Advocate Deepak Dhingra. Advocate Deepak Dhingra is the proprietor of Law Linkers and Company, New Delhi. He is practicing in Supreme Court and appeared in almost all the high courts in India. He has vast experience in handling arbitration matters, including international arbitrations, and have been involved in many leading arbitration matters within the country and abroad. He also appears in tribunals and commissions. Welcome, Advocate Dhingra, to our show.
Thank you, Mr. Goyal. Thank you for inviting me here.
Now, you have heard what Justice Chidambaresh, Senior Advocate Sood, and Advocate Bhargava has spoken. According to our two senior people here, they said the virtual courts are not the solution. But Advocate Bhargava has a different view. He says because if the justice is delayed, is justice denied, and because this pandemic has to be there for some more time, we cannot deny the justice because we have to delay the trials and others. So according to him, we should start the trial as early as possible, even virtually. Now, we would like to know the COVID-19 impact on criminal cases in India. Advocate Deepak Dhingra, please.
Thank you so much. You see, let me come down firstly to the point of virtual courts. Justice and Vivek Sood, of course, said that virtual courts are not a substitute, to which I fully subscribe. You see, this epidemic has been thrusted upon us. We never invited it. We were working very smoothly, courts were going on. Undoubtedly, there was a backlog, the issue concerning vacancies, but all of a sudden in March or mid-March, this epidemic surfaced in India and we had to virtually close down everything. So it was a very unfortunate situation. And as we pointed out, as everybody will also agree, that as on today, we never know as to what is the time frame within which we can restart the actual physical functioning of the court. But having said that, I just want to ask myself a question. There is virtual court. Undoubtedly, as on today, it is not a permanent substitute. Undoubtedly, it is not a permanent substitute. In physical hearing, we appear before the court. We are more trusting with the arguments. We express. Expressions are there. The justices listen. And many things happen, which after all, you can't avoid physical hearing. But then what to do? Today, as on today, if we open the courts for physical hearing, as on today I'm talking, when we are really every day, as I go by the news, yesterday we had approximately 20,000 cases which have surfaced in the country. If I correctly remember, at one time we're looking at figures of few hundreds. In Delhi alone, we have got almost 4,000 cases, detections every day, 4,000, which was once a figure on all India basis. So what is to be done? You see, if you open the courts, the problem is lawyers, the assistants, the staff, all have to be there. And the court staff has also to be there. Now, Justice Chidambaresh pointed out one thing, that the Supreme Court, as our High Court also, they're all centrally air conditioned. I mean, Supreme Court may be court-wise air conditioned, but our High Court is all air conditioners, whether it's toilets, whether it's bar room, whether it's everything is centrally air conditioned. So what to do today? We cannot really, we have to avoid effluence of people to collect at a single, at a single time, at a single space. Now, having said that, I'll come back to these points later, sir. Let me say what is the difference between the civil and the criminal litigation because the topic is the COVID impact on criminal litigation. Civil litigation is a litigation where a private wrong by a private individual against another private individual, which is unlike the case of a criminal wrong. I'll come down why I say this. In civil wrongs, we have got recoveries, defaults, we have got litigations concerning properties, we have got litigations concerning inheritance, we have got litigation, we have got arbitrations, we have got all others, we have got suit for possessions, we have got suits filed by landlord against tenants. So they are basically a private wrong against another private wrong, which an individual approaches the court for the purpose of adjudication of a private wrong which has happened against him. In criminal litigation, it's a crime against society, not only against the victim and the family. With due respect to all of them, it's a crime against society. It's a crime against humanity. That's why we have got state prosecuting. We have got state prosecution agencies which are prosecuting, whether for murder or for molestation or for robbery or even for any small offense. We have got state working for it. Now, I'm also aware of the private complaints which are lodged, A versus B, in a magistrate's court. I'm fully aware of that. But primarily, predominantly, we have got the cases which are where the state is the prosecution. Now, second point which I want to, or third point which I want to emphasize is that if the criminal justice is delayed, what happens to the victim or to the members of his family or her family who are looking for prosecution of the accused? They want the accused should meet his fate. So if that is delayed, as such, normally a criminal matter doesn't get over in few years. It takes a number of years. Plus we have got deaths where the accused die. We have got witnesses turning hostile. We have got witnesses who don't turn up in the court. We have to some extent where the prosecution fails to take home the offense. Above all, if there's a delay, what happens to victim, or in case it's a victim is a deceased, then what happens to the member of the family? We had a recent example, I don't want to name, but there where the family really for almost 8 years, they were before the court every day. The offense happened in 2012. So what happens to victims in case there's a delay? What happens to the family member? What emotional trauma they all go through? So undoubtedly, it's an immense setback. And please mind you, if we think that one fine morning in September, August, October, July, maybe somewhere, if we'll restart and everything will come back, and we'll start to have a system which was working pre-COVID, that let's say February or January or pre-March, mid-March, I'm sorry, it's not going to take place like this. We have to restart the code. Now, Mr. Bhargava said that we must start and we must we can have the hearings and the cross-examination going on through video conferencing or virtual court, if I heard him correctly. So the problem which arises is that if you ask a witness to be cross-examined through a virtual court, through video conferencing, I'm extremely sorry, neither he'll be truthful nor he'll be fair. So a witness has to be put physically in a witness box for the purpose of his cross-examination. Otherwise, we have got interrogatories, like we have got interrogatories in our civil litigation. The interrogatories are served upon the opponent, he quietly sits back, consults his lawyer, consults his colleague, and then come out with the ready-made answers. Can we have this sort of system here in criminal law, where 90% of the cases are witness-based? Prosecution relies upon the witness. The courts were granting bail, anticipatory bail, or concerning charge sheets. Eventually, in the trial, of course, it's a testimony of the witnesses which count. Now, we ask these witnesses to stay back at home where they are and to give testimony and be extremely sorry the entire system will fail. I agree with my colleagues here, and of course, Justice, that we have to, virtual courts are not substitute. Of course, they are not. But having faced the situation which we faced, which was basically we never expected, we can't really help it to bear with the system. And of course, the Chief Justice of India, the respective Chief Justice of the High Courts, and of course the learned judges have got all the data, have got all the statistics before them, have all the manpower. The government is there to give them, to provide them with all what they require for the purpose of coming down with a strategy, and which of course they will come down. So as on today, there is no substitute. And listen, allow the courts to allow the court. Now we have seen what happened when we had lockdown 1. At that time, it was basically how many cases we had, and today when we have opened the economy. Look at the state what we have. People and countries rather are thinking of having lockdown again. Now I do appreciate that lawyer community has also suffered immensely. But can we do it at the cost of life? Have we got the medical infrastructure in our country so as to really take care of the epidemic which has struck us? My respectful answer is we are not prepared. We were not prepared. We may be prepared in future now, but as on today, we have to be in this situation and leave it to the honorable courts for the purpose of devising ways and methodology as to how to take it further. But undoubtedly, there have been a delay which has to be borne for the time being. It will take some time, and as Mr. Vivek also pointed out, that we can have some easing measures for the under trials or maybe the convicts to have some kind of arrangement where they can be released for shorter time and furloughs and all these kind of things, which I fully appreciate. So my only take is that let's wait and watch for some time. But to open the courts as on today, when we have yet to reach the peak of the epidemic, shall be slightly, I think, shall be a little risky. And then please mind you, we are not only inviting lawyers to the court, we also have to have assistants. We also have to have court clerks. We also have to have other staffs at the court premises. And we have to have other court, I mean, not only our staff, but court staff also to be there. Now, what happens if this really spreads? All right, lawyers are a community which can afford to some extent. But what happens to people who will really suffer? And this is so infectious. It affects your respiratory system. It's unlike a flu. So my take is that let's bear for some time. But undoubtedly, I go with Justice and of course Mr. Sood and of course Mr. Bhargava. That listen, virtual courts are no long-term substitute. We have to take care of that. Ultimately, we switch over to the physical system. But I think we'll have to give some time for the purpose of switch back to the system. Till then, I think virtual courts are the only alternative which I can see of. Yes, in case a court thinks, which I doubt sincerely, that we can go for some sort of trial where the testimony of the victim or the prosecution witnesses to some extent can be through video conferencing. Well, I leave it to the courts to come down. But in all cases, I'm extremely sorry that will be far too frigid. Thank you so much.
Thank you, Advocate Dhingra, for giving your views that virtual courts are right now the only solution till the time this disease has not been over. But virtual courts cannot be the solution only because we cannot get the fair trial as far as the criminal cases are concerned, and we have to bear for it, and we cannot go with the cross-examination of the witnesses, etc., on the online or the virtually, because the witness can say anything and he will not be truthful. Now, my point is, like Justice Chidambaresh, that in India, we have already so much backlog. And the reason which earlier used to be given pre-COVID era was that because of the less, or you can say the judges were not there, because almost 1/3 vacancies there in the high courts. And even a data says that lawyers in India are far less than if we compare with USA. Like USA, we have a total number of lawyers are 13.5 lakhs for a population of about 33 crores, and India 20 lakhs for a population of 140 crores. Do you think the reasons for the pending cases was because of the paucity of judges as well as the lawyers in India? And if it is so, then what is going to happen after this backlog, which is now going to increase day by day due to the COVID? Justice Chidambaresh, please.
The pendency is mainly due to the fact that there is nobody to check, there is nobody to supervise effectively. A target should be fixed. Often target is not met. The cases are simply adjourned for the mere asking. Older cases should be given preference, firstly. Secondly, all the existing vacancies should be filled up. Huge number of vacancies are there in most of the high courts in India. Except the Supreme Court, in all other courts, vacancies are not filled up soon. This collegium system and this the selection process consumes lot of time indeed for judges to be appointed. Unless the judges' appointment is made fast, unless the vacancies are filled up, unless the best among the lawyers are recruited as judges, the pendency is not going to decrease. Then target should be fixed. Old cases should be given preference. Not the hi-fi and sensational cases should be given preference. There are older cases which are 10 years old, 15 years old, especially civil cases. If the voluminous evidence have to be looked into, it is simply adjourned. If the parties are numerous, somebody will be dead, then legal representatives will not be implemented. On that score, the case gets adjourned. So that the entire mechanism has to be revamped. A court manager should be appointed. For every district court, there should be a court manager. How to streamline the free flow of cases. And unless the vacancies are filled up, things are not going to improve.
Thank you, Justice Chidambaresh, for saying that unless the vacancies are not filled up, the cases pendency will not go. And you have suggested about that one court master to be appointed and see to it that all the pendencies to be cleared, the old cases to be taken first, instead of taking the new cases and try to dispose of them as early as possible. Although there was a suggestion, and you have mentioned about the collegium system and the selection process of the judges, although there was a suggestion earlier, like in terms of like we have in the civil services like IAS and IPS and IFS, there should be a IJS, the Indian Judiciary Service selection for the judges, so that it can be all India competition from where all the advocates who are eligible can apply and they can be selected and given proper training and make the judges either in the lower court or the higher court, whatsoever the cases will be. But that is a different discussion, which we will do it in the next some time. Now I would like to go to our senior advocate Sood. Senior advocate Sood, will use of technology give the justice to criminal cases? Justice Sood, please unmute yourself. Senior advocate Sood, please unmute yourself.
Yes. You just repeat the question.
Will use of technology give the justice to criminal cases?
In my view, we don't have the infrastructure, the technological infrastructure as of now, which can be applied to deliver justice in criminal cases through technology. But then, with whatever we have at this point of time, and with the pandemic on our head, we can use technology to some extent. It is very limited in its application. Let us understand the atmosphere of the court. A criminal court, a judge, a sessions judge or a magistrate, he is doing 5 things at the same time in the physical court. applications are being filed, bail is being recorded. So the whole system between 10 a.m. and 4 p.m. is highly efficient. That is how he is able to do 50, 60, 100 cases in a day. Now, when you apply that, in the virtual space, half the time the connectivity is not there. Then, the connectivity, then the audio problem is there, the video problem is there, and then getting all the parties together, and especially in the lower courts, the legal community has barely moved out from tick, 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 tick of the typewriters to the click, click, click of the computers. They have just barely moved out of that tick, tick kind of era to the click system, where you have at least some typing on the computer. Now, the legal community at the base level, defense lawyers at the base level in the districts don't have the infrastructure to have a video hearing and all that, and then getting the witnesses on board. And Mr. Dhingra rightly pointed out, how can you cross-examine a witness in a video court, in a video hearing? Suppose a witness, an uncomfortable question is asked to a witness in cross-examination in a video hearing. He will just switch off. He will just switch off and he'll say, oh, there is some bug in the system, and he will have a lawyer waiting somewhere to guide him. So the whole credibility of the cross-examination will be missing. Although video cross-examination has been done in exceptional cases, where the witness is in some foreign country, he's unable to move, he's ailing, he can't come to the court. In exceptional cases, we can have it, but we can't do it as a routine. So maybe, but a middle path could be found out. Maybe a witness can come to the court complex. He can be made to sit in a particular room, which is guarded appropriately, and then you can have a virtual cross-examination. So maybe a balance can be struck between what Mr. Bhargav has said and what Mr. Dhingra has said. So in my view, technology as of now is not the answer. Once things will open up, things will improve. Maybe, the courts can prepare for the next pandemic. If it happens, then you can have a better system in place. Technology, in my view, as of now, is not the answer to sort out this problem. See, the pendency itself is a pandemic. What to talk of this pandemic of COVID-19? Pendency is also a pandemic, and it has been there since time immemorial. So, in my view, some middle path has to be found out. We will all have to take some risk and come out of this zone of fear. Otherwise, this can be indefinite. I ask myself this question: if this pandemic peaks next year, are we going to keep ourselves shut? Are we going to keep our legal system shut indefinitely now? So somewhere down the line, if the paramedics can be working, the nurses are working, the doctors are working, the corporate world has opened up, airports have opened up. If everything is opening up, the judiciary will have to, maybe in the next 4 weeks, 6 weeks, 8 weeks, will have to come out of its shell and open up with the risk that everybody is facing. Everybody, we are no different. The legal community should not be so different. We are all the same. We are all citizens after all. So having said that, technology is definitely not the answer at this point of time to sort out the criminal cases that are overburdened in our legal system.
Technology is not the only solution for the overpendency of the cases, because already according to the pendency itself is a pandemic. But what you have said about that, when everything is open, why not judiciary? In my personal opinion, because in judiciary, people try to engage even the senior lawyers, and senior lawyers are of the age of sometimes senior citizens. Even the judges of Supreme Courts are of that age, which for medical fields, the government is not allowing above 55 or 60 years to go to the hospital, or to even the police officers are not supposed, or even the police constables who are above 55, they are not supposed to go for the duty where this is. Yeah. Anyway, that is another view. Now, I would like to go to Advocate Sunil Bhargava. Advocate Bhargava, you were mentioning that we should do for the virtual. Now, you are practicing in a, I will say, tier 2 or tier 3 city. Now, where the position of the internet, which you know very well, is very bad. Many times it happens, even in the metros also, we are facing lots of problem about the internet. And in that case, as no proper internet facilities in small cities and villages, how the advocates will be able to file cases to get relief for their clients, as well as what Senior Advocate Sood said, that the lower courts are having even the advocates are not geared up to use the technology. According to him, the majority of advocates or few of the advocates. So what are your views? Keeping in mind that you have mentioned that everything should be done virtually, but the problem with the virtually is, main hurdle is the technology, our infrastructure. And if we will go for the improvement of the infrastructure or the development of infrastructure, it may take 1 or 2 or 3 years more. Until the time that whether the pandemic will be there or not, we don't know. Advocate Bhargava, please.
I'm so sorry, Mr. Goel. I think Mr. Bhargava insisted for reopening of courts, if I heard him correctly.
No.
He was not in favor of virtual courts.
No, I know, sir.
Sorry? No.
I didn't say reopening of courts. I said we have to go through the process of working of court.
Virtual. He says virtual.
Virtual.
Okay. All right. I'm sorry. I missed
It's okay. It's fine. Well, I have to say, tough times, they really call for tough measures. We know it's tough time. We know how much limitations are there. You say the internet limitation is there. You say people will not be able to work it out. Well, we have reached, we are working. So this is tough time. Infrastructures will have to be built very soon because of this tough time. It has to be done at immediate measures. It should be done at the earliest from the grassroots level, because we are the ones who are facing this basic problem. Because if you talk of capital, if you talk of Delhi, if you talk of big cities, people are taking precautions. But where we come to villagers, where we come to people who are less educated, they will believe more in God and less in wearing a mask. So we are basically working with those people who are more prone to this illness. So that is also to be considered. So it is tough, we know. But virtual, like my friend said, it will be a problem because we have faced this. We tried this for 2 days. When our courts opened, we had this judge was sitting in his chamber with a laptop and he was working there. We, with a laptop owned by the court, it was not ours. It was court's in another room. We were sitting there. And the person who was the aggrieved was sitting in another computer in a same room, but to the distance of about 20 feet. So now, we put whatever we have to it. The can record and hear it. It is a recording done, which was there. And then only we could work peacefully. Because a lawyer who's cross-examining, who's examining his act, his mind, everything should be in the file, in the witness itself. Now, when the witness is alone, sitting in front of a computer and a camera, he cannot talk to anyone. He cannot take any advice. So that is how I meant by saying, if we don't start trials early, then the criminal trials which are already pending, it's about 3 crores if I'm not wrong. 3 crore trials are pending right now in India. That's what I read the other day. If it is 3 crores,
see, we lost Advocate Bhargava, although he is advocating for the virtual. Now we can see the result of virtuality, what is the condition. And if a very important case is going on, when there is a murder case, when the cross-examination is going on, what will be the outcome of that case? One can imagine. Because Advocate Bhargava should understand, we have about 6.5 lakhs villages in India. And to upgrade the infrastructure in all the villages at this time is not that possible. Advocate Bhargava, we lost you for some time, and still you are not been connected. We can't hear you. Okay, so now you can imagine the condition, and I think this is the reply which your internet has given, not you. So we will wait for you to connect. So we will come back to you again. Meanwhile, I would like to go to Advocate Dhingra. Now, Advocate Dhingra, you have listened what others have mentioned, the Honorable Justice Chidambaresh, as well as Senior Advocate Sood, as well as our Advocate Bhargava. And they all were saying differently, because virtual courts are not the only solution, but there is no other way for the time being. But now my question to you is, now India is in opening phases. We have already completed opening one, and I think that tomorrow or from Monday, first, we are going to have another opening phase. Expectation is that again crime will increase, because the crime has gone down due to the lockdown. But once you will start opening, then the crime will definitely increase. According to you, how courts will cope up with and deal with increased number of criminal cases virtually, if we are not going to start physically, which according to you all, it is not possible for the time being, then how the courts will be able, when the figures of April, I have already quoted that so many less cases were done versus what we have seen in the last year. Advocate Dhingra, please.
Please, sir. You see, as I earlier too pointed out, that basically the prosecution in these cases is by the state. For state, we have got either the state working through a police station, or we have got other state-formulated agencies like Enforcement Directorate we have got, like Crime Branch we have got, like CBI we have got, like other things we have got. So if a crime gets committed, then what to follow? A complaint, FIR, a charge sheet, and thereafter the matter goes for trial. In between, we have got certain procedure where an accused can seek bail, can seek anticipatory bail. Accused also has the right to go for questioning, has got a right to go to the court for the purpose of taking, say, certain measures. There's certain coercive steps should not be taken against him. So all this can go on. Upward, tell me, since the start of this virtual hearings, on criminal side of the courts, on criminal side of law, we have got three sort of matters which are being figured in every day. And they are predominant. Why I say? Because we have got more of criminal litigation today than civil litigation. Why I say so? Because we have got bails, we have anticipatory bails, we have got people going for questioning against a prosecution which has been launched. We have got people going against the state that no coercive action should be taken, or certain other measures which are there. Civil litigation is far less, because civil litigation is basically concerning the COVID-related cases. Because everything is standstill today. Contracts are not being given effect to. Landlords have to bear with the suspension of rent. The other certain force majeure clauses are applying as far as civil litigation is concerned. So now, as far as criminal cases is concerned, if supposedly crime is there and crime increases, a prosecution is not bound. Its hands are free to arrest the accused. And if the accused wants anticipatory bail, the courts can grant them relief through virtual hearing. Next step is accused is arrested. He can still apply for bail through virtual hearing. There's no problem about that. Now, a charge sheet has to be filed by the prosecution. There is no embargo. The prosecution cannot file a charge sheet in the court. And we have seen that prosecution has filed charge sheet in the last 90 days or 60 days when the epidemic and we started the virtual hearing. And ultimately comes trial. But trial in all the cases which are going to come up is not going to commence before 2021, somewhere later in 2021 at the earliest. And that is about 12 months or maybe 14 months behind, from now. So at least this process, even if the crime increases because the people are coming out, the people are right in the streets, and people, all the criminals, the activities again start. But then they can undoubtedly go for, in case they are entitled to relief and they want relief, they can go for virtual relief. There's no problem about that. The courts are sitting every day out for giving release to them. So if the crime increases, no problem. Virtual courts are there. We don't have to have physical courts for that purpose. Please appreciate the fact. So in case crime increases, no problem. We can go for virtual hearing. But you see why I say virtual hearing today, sir? Because how to now, we have yet to touch the peak. I'm going by social media. I'm going by the news reports. I'm going by the newspapers. I'm going by everybody which is talking. Every third day, every second day, we are finding our own colonies in our own lanes. But listen, there are notices being pasted outside. There is a COVID patient now. So how to cope with it? And our medical infrastructure is not that good that we can really go to the hospitals for the purpose of admitting ourselves, or can self-quarantine ourselves also, because in self-quarantine is fine, but then we need, sorry, Mr. Bhargava is back.
No, yeah.
We need, people require hospitalization as well. So for that reason, as far as this is concerned, if the crime rises, our courts are very well equipped to go for virtual hearing. But yes, as said, virtual hearing is not a solution, a long-time solution. But as on today, you cannot avoid this. You cannot really do away with this. You cannot reopen the courts. Like I asked myself a question. All right, you have reopened, you have unlocked the economy. What's the sale? Are the shopkeepers opening their shops? No, they are not. The desperate ones are opening. Are the malls open? No. We have got street hawkers. We have got street hawkers. We have got other people also. But they're desperate to open the shop. They can't help it. But please mind you, people are out of fear. They are not going to the shops. The rushes which you see in the streets are undoubtedly the people who are desperate, who have to go to their offices for the purpose of having a bread and butter for themselves. So in case the cases rise, the courts are well equipped to grant interim leave, and there is no bar with the prosecution not to proceed with the prosecution. As far as evidence is concerned, trials are concerned, well, we can take the courts can take the call later once we have got some recession as far as evidence is concerned. Thank you.
Okay, thank you, Advocate Dhingra, saying that even if the crime increases, the virtual courts are competent enough to give for the hearing of the case. But
and the prosecution can proceed to prosecute. There's no problem about that. They can lodge an FIR, they can lodge a complaint, they can go for charge sheet, they can go for recording of statements of the witnesses. There is no bar.
No, but there is no bar. But according to you, earlier you have mentioned also that it's not possible to cross-examine a witness fairly.
That's trial.
Yeah, that's what I'm saying.
So what I'm saying is, in case the crime increases, we are not going for trial instantly.
Okay, so according to you, if the crime increases, the immediate disposal can be done the immediate hearing can be done for the bail or injunction, etc. But for the trial, we have to wait, and that, according to you, it can be 2021. I'm
just giving a figure of 2021. I'm saying that in case a crime happens today, let's say today being 29th of June, the trial we are not going to see trial in 2020 or 2021. This is a very, very conservative thing which I'm giving, that this is the court's clear express. Otherwise, trial takes 4 to 5 years in the law, maybe later, maybe more. It's not. I'm just giving a very conservative estimate.
Okay.
But if you expect the whole thing 14 months right from today. That's
okay. Thank you, Advocate Dhingra. Advocate Bhargava, you want to add something because your connection was lost, and I was telling that because this is the problem which is going to happen when you are advocating about the virtual court hearings and everything. Yes, Advocate Bhargava.
Yeah, so that's what I meant by what we meant by the infrastructure improvements was one of this also. We can improve this visual in courts also. Okay, fine. With different parts, at times it doesn't work, I do believe. But then we can wait. If, like, the witness is there, the judge is also looking at the witness is alone in the room, lawyer is there, witness can also have his lawyer at a distance. Then, we are away from this pandemic. It will not be a problem for us to think that we will also be sick after working like this, as it is stated. So my feeling was, whatever we can start with raising of the infrastructures, improving everything with the internet also, like I just missed you people for certain time, I don't know what happened in between. But if it can be improved, I think we should go for criminal trials at the earliest. Otherwise, if too much time is given, people will not wait for justice, and they will start taking, whatever the events that happens, same way they will also start behaving like an accused, which we never want in the society. That will not be good for the society. If in revenge, I wait for 1 year, maybe in a murder trial, maybe I wait for a year or two. But if I have lost one of my keen ones, I'll not wait much. If there is no trial, he's out on a trial, he's on bail, then maybe we take more. That is the reason. In the society, it is more important that we keep society at bay. Society should be at peace. We are fighting against this pandemic, so we should fight against criminals also. We should be both vessel. Basically, I'm a lawyer for accused only, but I feel that when it comes to criminal trial, it is complainant and the accused both. So we have to work. And as soon as possible, how much time our Honorable High Courts, Honorable Apex Court, they take time to make this arrangement. I think it should be done at the earliest. The sooner, the better is for the whole society. This is what I feel.
Sooner, better for the whole society. Yes, Senior Advocate Sood, you would like to say something?
May I just add? Maybe, you know, we can think of a hybrid system, you know, where we use the physical and the technology, both, you know, effectively in these times, so that, you know, we become more efficient. Our criminal justice system becomes more efficient. For example, you know, in a courtroom, in Tisadari court or Saket court or Karkaduma court, typically in a lower court, you know, why don't we divide the courtroom with some wooden, some partitions, you know, where you have a judge who is isolated, and then one side is the prosecution, one is the defense, with some partition, some screen. For example, I took my father to a doctor. You know, he had some back problem. So the doctor had a screen, you know, had a plastic screen in front of him, and he was sitting at a distance of, say, 4 or 5 feet. Like, for example, now the cabs, the taxis, you know, between the driver's seat and the back seat, you have a plastic screen. So some hybrid methodology could be found where the base level lawyer who does not have good internet connectivity, you know, they could be a computer kiosk for the prosecution, for the defense, and the judge. The judge may sit in his chamber, some way, you know, where technology and the physicality can come together in a hybrid way, and then so that we can carry on with the system with more efficiency. See, you know, we have not spoken about the livelihood of the lawyers of the legal community at the base level. You know, after all, we are in some kind of a glass house also. You know, we are in our comfort zones because, you know, God has been kind to us, you know, with the legacy and the background and anything. It's all God-given destiny that we are well off. But what about the base level legal community? I was reading the other day that lawyers in Bombay have gone with the migrant workers in those trains, and they are begging for food. Because see, these small-time lawyers, the base-level lawyers, you know, the notaries, the oath commissioners, who earn on a daily basis, who earn on a weekly basis. I mean, just imagine their predicament, and plus they don't have technology. So how will they function? So we have to look at the universality. We have to look at everybody's interests, you know, rather than looking at only a few interests. So in that view of the matter, why can't we have some hybrid mechanism where everybody may gain in the process?
Thank you, Advocate Sood, for giving your suggestion that it should be a hybrid system where we can have the virtual as well as the real court room in the physical also. Now, my last round, I would like to go to the Justice Chidambaresh. Justice Chidambaresh, would you like to give any suggestions to the government or the Supreme Court or advice to the public at large? Justice Chidambaresh, please.
So, as of now, we have to continue with the virtual court system only, at least for a period of 3 months. Then improvise the present video conferencing system. The one that is used in Kerala is Zoom. Now the ministry says don't use Zoom for security reasons. As far as the Supreme Court is concerned, it is video. It is not at all satisfactory in the sense it is constricted. The manner in which the lawyers could freely argue, or we could hear the responses from the judges, all are restricted in this present platform. So that unless we improvise the structure, we cannot continue with the video conferencing. And there are certain lawyers who prefer to sit at home and work. Work from home is a concept which is acceptable in IT industry, which is acceptable for a chartered accountant, but it is not acceptable for a lawyer. For a lawyer, he should have human access. It is often said that the credibility of a witness is judged by his demeanor in court. How is it possible in a video conference? We have to have video conference for summary procedures like habeas corpus cases or bail, anticipatory bail or transfer. As far as serious trial is concerned, we have to go with the actual hearing also. As Mr. Sood said, a hybrid system is inevitable. We have to go with the physical hearing also, but then restrict the postings to few cases, see that those cases are not adjourned at any cost, and then the trial is finished off within 3 days. In that manner, we can have a progress and avoid the stagnation.
Thank you, Justice Chidambaresh, for giving the suggestion that what system right now the courts are using is not up to date. You mean to say that Kerala court was using earlier the system, which is good, but now there is new directions to use, not to use that system, but the system which they are using is not up to the mark, and that is required to be upgraded. And the hybrid system, according to you, is also inevitable. Now I would like to go to Senior Advocate Sood. Senior Advocate Sood, your suggestions to the government or Supreme Court or advice to the public?
In my view, I feel that sooner or later the courts should open. You know, judges are brave, the legal community is brave, and we'll have to come out of our shells. We can't be in our shells indefinitely. Of course, while maintaining social distancing and while maintaining some parameters, we'll have to come out, and there will be some suffering, but the medical help is there. You know, a lot of medications have come and a lot of things have come. The mortality rate is going down. It is, so someday we'll have to open up. Till then, we can think of some hybrid measure, whereby the legal community can discharge their duties more effectively at the base level. I will not suffer. I'm okay. Mr. Dhingra is also fine. Justice Chidambaresh and Mr. Bhardwaj, we are all, God has been kind to us. So we are sitting in our comfort zones. But I'm looking at my, colleague, who comes from Hapur or Ghaziabad. He comes to the Patiala House Court in the morning, who comes by train to Tisazari, earns his bread and butter, and does some work, some duty towards a poor litigant, and goes back in the home in the evening. See, now I must say, by lockdown, criminality will increase also. Maybe the car accidents may not happen, but very soon, you will have people on the streets extorting money, using violence, robberies, dacoities, kidnappings, abductions. They have already begun, let me tell you. There have been some incidents where I was reading some pilot of an airlines was going to the airport at about 1 a.m. in the morning, and IIT Delhi, he was waylaid at gunpoint, he was thrashed, all that wallet was taken. So, people who have lost their livelihoods, people who have become unemployed, they are going to come on the streets. Ultimately, the economy has to open. We cannot live in this masked economy forever. We'll have to open, we'll have to come out. Now, yesterday, WHO says that asymptomatic cases do not transmit COVID-19. So big deal, big deal. We'll have to come out in the open. The economy has to open. And if the economy can open, why not the legal system? The legal system is no different. It cannot carve out itself as, from some other planet. We can't be distinct from the other communities. If the hospitals can work, if a hospital is an essential service, so is criminal justice. So ultimately, we'll have to open sooner or later with the limitations that are in place. Okay, thank you, Senior Advocate Sood. If hospital is an essential service, so the courts and the judiciary also. And giving the, according to you, the crime is going to increase because of the unemployment, because of because people have lost their jobs, so that they will come on the road. Although, in my opinion, my suggestion will be advice to the public is, please don't do any crime. Because if you will do any crime, it's not so easy to get the justice. Anyway, now I will like to go to Advocate Bhargava for his suggestions to the government or the higher courts and advice to the public.
My suggestion, basically, what I feel is, because I have one person at home who just completed his law last year, working in Delhi, and now he has nothing to do for last 7 months. 8 months he's sitting at home. I can understand his frustration. for 4 months with this and facing other problems also. Now, if we don't start, the government's suggestion is we have to open courts. We have to do it because otherwise people will start losing faith. They will be more, they will not be worried about going to jail, maybe doing any crime because they know if it is less than 7 years, they will come out again and then they will do it again with no problems. We are staying in a place, Delhi, you just hear one or two. Where we are in that area, the criminality is much more. There are much more cases and they will increase, what my elder brother has just stated. If they are on the rise, they will rise more. Then what will happen? So to stop that, we have to start working in court. The visual courts has to be there. The sooner it works, the sooner it goes for trial, the sooner it works on bail applications to be heard on merits, then the person who is thinking of doing something wrong will be at a check. So when we work and we go to the court, that distance maintaining, that difference, we have to make, very correctly stated, that we have to make 3-4 chambers, maybe in the court itself by partition. Like I told you earlier, they are making a curtain in between, a transparent curtain between us and the lordship. So when that curtain is there between me and the lordship, why can't it be between me and the witness and the person who's attending a witness as a lawyer? So once these precautions are taken, and once the precaution that less people are entering the court, and they're of course going into the court after a thorough checkup. Maybe there are silent patients are there. But with that check, if they start working, then young lawyers will not have frustrations. They will come back to their job, which they have all lost. How many people are keeping juniors right now? I don't know, because it's a problem. When there is no work, what will the juniors do? What will they learn? How will the young lawyers learn? That facts are there. So once it starts visual and it is done, and along with this also starts. I mean, making chambers and working of the court in better way in the maximum. Maybe I don't mean, because when we started practicing, I still remember a sessions court used to work on Monday, Tuesday, Wednesday in evidence of the witnesses, and Friday, Saturday, Sunday, that used to be finally for investigating officers, formal witnesses, and coming to the trial. So why can't we finish the trial as used to do about 40 odd years back? It is because of pendencies. Once that is gone, then we can start off early. So my saying is, with all the precautions, if everything is done sooner, in a better way, that is my request to the government also. See the best, what they can do the best. They are also experts. They are much more experienced people there. If they can be heard, and the work starts. This is my thing. Otherwise, if criminal cases keep pending, criminality will be on the rise. That's what I say.
Okay. Thank you, Advocate Bhargava. And you have given a suggestion that sooner we should start the actual courts with definitely all the precautions, and the virtual courts should also continue so that the young lawyers will not get frustrated. Yes, it is also possible that for the seniors or those who are senior citizens, advocates, they can do on virtual, and the young lawyers, although the medically still we can't say that COVID can spare only, it is only against the senior people, not against this. That is a separate thing. Now, the last word, people say the last word is very important. So, Advocate Dhingra, now what are your suggestions to the government or to the higher courts and the advice to the public?
I'm extremely sorry, my last word will not count here. I'm sitting with very esteemed guests, including Justice Justice Chidambaresh and Vivek Sood, and of course our colleague from Mathura. So my last word will not count. But sir, I just want to say one thing. You see, a lot has been said that if hospitals can open, why can't courts be open? Courts can also open like hospitals, provided the judges, the lawyers, the litigants, the court clerks, the court staff also behave like doctors. When we go to a hospital, I recently went down, doctor tells you, or even nurse, even the staff tells you, please kindly go and stand in the queue, sentence yourself, please come. We very carefully, very obediently go down there and stand in a queue and then try to take precaution. everything. So everybody in the hospital is taking precautions. If the court have to function like hospitals, then we all also must behave like doctors. But the problem which comes up is, sir, when there's a surge of people entering the court, working at the court level, the rush of the hour is so much, like, all will agree with me, the practicing lawyers, of course, that when we go to the court at 10 a.m. or 9:30 a.m. or 9:40 a.m. or 10:15, 10:20, the way the rush is there in the court, forget about security, we even don't care about the security. Do we care about security? We are in a rush. We have item number 1, then we have item number 3, then we have item number 13, and we rush from court to court to court to court. So how do you, in hospitals, this is not the rush. So I fully appreciate with everybody that, listen, if hospitals are open, courts too can open, but provided we take measures. As far as the other question is concerned, sir, well, virtual, I fully appreciate with everybody that virtual courts will take time, as I said, will have to be an order of the day as of now. But as far as trial is concerned, we can go for physical hearing, but at a little later point of time, where the courts can take up the older matters first, like Justice opined in his very first round of talks, that we can take older matters, try to expedite them, try to maintain all social distancing and other norms which are prescribed, and can carry on, and then wait for some recession by the epidemic so that we can come back to virtual courts as also to the physical hearing. Thank you so much.
Thank you, Advocate Dhingra, that we can do both the things, virtual as well as the physical. But right now we have to do virtual only. And in case if we want to open the courts, then we should also behave like doctors or the medical workers, as in the case of hospitals, so that the total precautions can be taken. But because of the surge of the public, it's not that easy to start, but we have to do it if the pandemic will continue. So today you have seen the legal luminaries have given their views, and they are very much worried about the public at large, whether it is for victim or for the accused, for both of them. And they have given their views very, very frankly that, okay, right now we cannot get that much faster justice what we were getting even earlier. Now, because of the virtual. But the time has come when we have to come out with some solution, whether it is a hybrid solution or something which can create an atmosphere with full precautions that the courts can work virtually as well as physically once the pandemic will go down slowly and slowly. So today our telecast, which was shown live on V4 News, News Karnataka, Global TV, Malnadu TV, as well as on Facebook and YouTube. Please keep watching our show at 11 a.m. Tomorrow is again a very powerful show, that is the COVID-19 impact on labor. And we will be joined by the chairman of labor, All India chairman of Labor Welfare Board appointed by the Government of India. We have also the one-man expert commission for the labor and workers. He will also be there, that's from the government side. And we will be joining 3 union leaders, the president of the All India BMS, and we have the from INTUC as well as from CITU. So that will be again a very powerful thing which we want you to see. And thank you very much to Justice Chidambaresh, Senior Advocate Sood, Advocate Bhargava, and Advocate Dhingra to join us and give your frank views. Thank you very much. Thanks a lot.
Thank you so much. Thank you, everybody.
Thank you. Thank you very much. Thank you. Thank you.